Welcome back to the channel. Today, we're discussing one of the most significant and widely misunderstood IRS rulings of the past decade, IRS Ruling 2016-44014. This private letter ruling fundamentally changed how Crummey trusts function in estate planning, and frankly, most people haven't adjusted their strategies accordingly. Let me start with a shocking statistic. According to the American College of Trust and Estate Counsel, approximately 40% of high-net-worth individuals using Crummey trust strategies are unknowingly non-compliant with post-2016 IRS guidance. That's millions of dollars in potential tax liability waiting to be discovered during an audit. But before we dive into the ruling itself, let's make sure we're all on the same page about what Crummey trusts are and why they became so popular. The Crummey Trust, a brief history. Crummey Trust gets its name from a 1968 court case, Crummey v. Commissioner. The basic premise is elegant. You want to make gifts to a trust that qualify for the annual gift tax exclusion, $17,000 per recipient in 2023, adjusted annually for inflation, but you don't want the beneficiary to have unfettered access to the trust funds. Traditionally, for a gift to qualify for the annual exclusion, it had to be a present interest gift, meaning the recipient had to have immediate access to the money. But with Crummey trusts, attorneys devised a workaround. Here's how it worked. You establish a trust and make annual gifts to it. Upon receiving notice of each gift, the beneficiary receives a letter, called a Crummey letter or withdrawal notice, informing them they have a limited window, typically 30 to 60 days, to withdraw their proportionate share of the contribution. Even though most beneficiaries never actually withdraw the money, the mere right to do so technically qualifies the gift as a present interest. This strategy became wildly popular because it allowed families to 1. Remove assets from the donor's taxable estate. 2. Leverage the annual gift tax exclusion. 3. Keep assets in trust, growing tax-free. 4. Provide significant wealth transfer benefits. For example, a married couple with 2 adult children and 4 grandchildren could gift $17,000 times 8 beneficiaries times 2 spouses equals $272,000 annually while using 0 of their $13.61 million lifetime exemption as of 2024. Over 20 years, that's $5.44 million removed from the taxable estate, completely tax-free. The problem, IRS Ruling 2016-44014. Now, let's discuss what changed. In 2016, the IRS issued Private Letter Ruling 2016-44014, which fundamentally challenged the assumptions underlying Crummey trusts. The ruling involved a specific fact pattern. A donor had established multiple trusts with withdrawal rights for various beneficiaries, but the trustee had discretion over how to allocate income and principal among beneficiaries. Here's the critical part. The IRS determined that when a trustee has broad discretion over distributions, and when a beneficiary's right to withdraw is limited in such a way that they cannot realistically be certain they'll have funds available to withdraw, those gifts may not qualify for the annual exclusion. In other words, the present interest argument fell apart. The IRS reasoned, if a beneficiary has the theoretical right to withdraw $17,000, but the trustee might not have actually received or allocated those funds to that beneficiary when the withdrawal period expires, is it really a present interest gift? The answer the IRS gave was, not necessarily. This represented a seismic shift in estate planning strategy, and it opened the door to significant tax exposure for anyone using these trusts. How the trap works. Specific scenarios. Let me walk you through exactly how this trap triggers using real-world scenarios. Scenario 1. The multi-beneficiary trust. James is a successful entrepreneur with a net worth of $8 million. Working with his estate planning attorney, James established a trust for his 3 adult children and 4 grandchildren. Each year, James gifts $17,000 to the trust per beneficiary. That's $119,000 annually, 7 beneficiaries times $17,000. Under the old Crummey trust rules, James assumed all $119,000 qualified for his annual exclusion. But here's where it gets dangerous. The trust document gave the trustee discretion over distributions. The trustee, after receiving the $119,000, could allocate it as follows: 40% to the Children's Education Fund, minus 35% to healthcare reserves, minus 25% to accumulated principal, under IRS Ruling 2016-44014. The question becomes, when the Crummey letter is sent to the grandchildren, they technically have the right to withdraw $17,000 each. But if the trustee only allocated, say, $8,000 to immediate distribution pools and $9,000 to principal reserves, did those grandchildren really have a present interest in the full $17,000 or just $8,000? The IRS position is that gifts may only qualify for the exclusion to the extent the beneficiary has realistic access to withdraw funds. If the trustee's discretion creates uncertainty about what's actually available, the gift might lose its exclusion status entirely. In James's case, if the IRS audits him and reclassifies even $100,000 of gifts over 10 years as non-qualifying, he suddenly consumed $100,000 of his lifetime exemption that he thought was protected. At current estate tax rates of 40%, that's $40,000 in additional taxes, plus interest and penalties. Scenario 2. The Dynasty Trust Problem. Consider Patricia, who established a dynasty trust designed to benefit her children, grandchildren, and great-grandchildren for generations. Each year, she made gifts of $17,000 per beneficiary, thinking she was leveraging her annual exclusion. However, the dynasty trust structure included a provision allowing distributions to the trustee's discretion for any beneficiary, with a sprinkle provision enabling the trustee to allocate income unevenly. Under the pre-2016 interpretation, this structure was fine. But post-2016-44014, the IRS has argued that when beneficiaries are numerous and distribution rights are uncertain, the present interest requirement fails. The audit found 30 annual gifts, 1990-2020, 15 named beneficiaries across generations, average gift per cycle, $255,000. The IRS reclassified $4.2 million of gifts as non-qualifying. This consumed Patricia's entire lifetime exemption and created a $1.68 million tax liability, 40% times $4.2 million, plus penalties and interest that could bring the total to $2.4 million or more. Scenario 3. The contingent withdrawal right. Michael's situation is slightly different. He established a trust where beneficiaries only had withdrawal rights if the trustee deemed it appropriate based on the beneficiary's financial condition. This conditional withdrawal right, dependent on trustee discretion about whether to exercise it, fails even more clearly under IRS 2016-44014. The IRS explicitly stated that when withdrawal rights are contingent on someone else's subjective determination, they don't qualify as present interests. Michael's exposure, $350,000 in reclassified gifts over 7 years, creating $140,000 in additional tax liability. Data and expert insights according to analysis by the Tax Foundation, 2019. Post-ruling audit activity on Crummey trusts increased by 340% in fiscal years 2017-2019. The IRS began specifically targeting these trusts in its examination program. Professor Jay Sold of Rutgers Law School noted in his 2020 article for the ABA Tax Times, IRS Ruling 2016-44014 represents the agency's most aggressive position on present interest doctrine in nearly 3 decades. Estate planners who continue using pre-2016 Crummey trust structures without modification are exposing their clients to significant audit risk. Further, a 2021 survey by the American Academy of Estate Planners found that only 52% of estate planning professionals were familiar with the ruling's implications for their current client base. What you need to do right now: first, audit your existing trust documents. If you established a Crummey trust before 2017, you need to review it immediately for the following risk factors. 1. Trustee discretion. Does the trustee have broad discretion over how to allocate gifts among beneficiaries? If yes, you're in the danger zone. 2. Vague beneficiary classes. The broader your beneficiary class, the higher the risk. Courts and the IRS view large, intergenerational beneficiary lists with skepticism. 3. No segregated accounts. Best practice post-2016 requires segregating each beneficiary's withdrawal rights into separate, identifiable trust subaccounts. If your trust doesn't do this, you're vulnerable. 4. Conditional withdrawal rights. Any withdrawal rights that depend on trustee approval fail the present interest test entirely. Second, consider working with your attorney to implement protective amendments. Create explicit subaccounts for each beneficiary. Ensure beneficiaries have unconditional withdrawal rights. Limit trustee discretion over allocation. Use different trusts for different generations or beneficiary groups. Implement hanging power language, a modern technique that addresses some IRS concerns. Third, if your trust is vulnerable, consult with a tax attorney about disclosure options. Filing a Form 8833, Disclosure of Inconsistent Treatment, provides some protection if the IRS later challenges your position, as long as you've disclosed the inconsistency. Conclusion: IRS Ruling 2016-44014 didn't eliminate Crummey trusts. They're still valuable, but it fundamentally changed how they must be structured. The days of loose, flexible Crummey trust architectures are gone. The families at greatest risk today are those who set up these trusts in the 2000s and 2010 based on pre-ruling planning and haven't updated them. Each year that passes